Welcome to the Glenn Rasmussen Fogarty Hooker podcast series. My name is Trent Cotney, and today's topic will be notices to owner. Now, when you're talking about a notice to owner, you're referring to Florida construction lien law. In particular, you're talking about Section 713.06 Florida statutes. Now, that statute has everything that you need in order to understand how to properly serve a notice to owner. It tells you the form you need to use, how to go about serving it, and who is entitled to receive it. So if you ever have a question about notices to owner, make sure you check out 713.06 Florida statutes. What is a notice to owner? A notice to owner is a document that those lienors that are not in privity with the owner are required to serve before they can perfect their lien. What does that mean? That means if you are a subcontractor, a sub-subcontractor, or a supplier to a prime contractor, a subcontractor, or a sub-subcontractor, those types of potential lienors, anyone that doesn't have a direct contract with the owner has to serve a notice to owner. The notice to owner must be served within 45 days, no later than 45 days from the first day of work or the first day of supplying materials. And it must be served on everyone upstream. So for example, if you are a sub-subcontractor, you'd have to serve it on the subcontractor, the prime contractor, the owner, and anyone that's listed on the notice of commencement that's entitled to receive the notice to owner. How do you go about serving it? I generally serve a notice to owner certified mail return receipt requested. The statute says that you can serve it in other ways, but this is usually the most cost-effective and the most prevalent form of service. When you're serving it certified mail return receipt requested, you normally get a green card back that indicates who received it and when they received it. So if there's ever an issue as to service, you've got that as evidence. A few practice pointers and things to keep in mind. First is that when you are serving a notice to owner, make sure that you serve it and have it in their hands within 45 days. Do not wait to the 45th day to drop it in the mail. It must actually be received by everyone that's entitled to receive it within that 45 days. Second thing to keep in mind is make sure you properly identify the scope of work in your notice to owner. I'll give you an example. This is the current notice to owner form as of the date of this podcast. There's a warning up top, and down below it talks about the scope of work that you're going to be doing on the project. Let's say you start off a project and you are doing roofing improvements, and you identify roofing improvements on the notice to owner. Halfway through the project, the owner asks you to do some structural improvements. Well, you would need to amend your notice to owner to reflect that additional type of work. Otherwise, you risk your lien being limited solely to the roofing improvement work that you did. Final practice pointer is make sure that you identify the parties correctly. And one way to go about doing that is get a copy of the notice of commencement. How do you get it? It's recorded in the county where the project is located. If you can't find it in the public records, then normally it is posted on the job box on the project site. Another thing that you can do to verify the owner information is to cross-check it with other sources. You may go to the tax appraiser's website or the property appraiser's website, obtain that information. On certain occasions, I even obtain the deed itself to give me the proper physical and legal description of the property that I am seeking to serve the notice to owner on. And that, in a nutshell, is the notice to owner. If you've got any questions about this topic or any other podcasts, please feel free to contact me at the phone number or email at the end. Thank you.